counsel's advice that we absolutely did.
Well, he
Follow
said
Wyoming state statute.
he explained to you what new evidence. I'd like you to go back and look at his explanation. He explained to you what new evidence actually means, and he explains what new evidence means in a court of law. He said that this is not a court of law.
That's right.
Now, if I had the money, I believe over that situation, I could sue you and win. Because in a court of law, he gave you what new evidence means. It has to be substantial and very new to the situation. So I would like you to review what your counsel said. I'm sure that
59, which defines new evidence sufficient to have a new trial, is material for the party applying, which the party could not, with reasonable diligence, have discovered and produced a trial.
Bingo.
And I don't know that I can honestly answer what's new evidence or not, but I think one issue that should be pointed out here when we are considering this, and it's your decision to consider that, this is rules for a trial. This is not a trial. And to apply it exactly the same as the court would do, I don't think is the correct application of the law. And for one example, if this were a trial, a person speaking before or against would not have the opportunity to walk up and submit a petition the night of the hearing, which contains a certain number of names. That doesn't happen at a trial. At a trial, everything that's going to be submitted for evidence has got to be exposed to those other side, usually months before.
New evidence, as described by our county attorney. Part of it, I didn't get the exact wording, but part was basically it was something that could not be found by using due diligence. Is that, correct me if I'm wrong. I jotted down the five things that Mr. Tyler listed as new evidence. Number one was the concerns of the residents. Now, there was concerns 2 years ago when they were rezoning out there. Does it not seem like due diligence would have been going out and kind of checking with the residents before they put in the zoning application and try to resolve some of these issues in advance? He said the petition was new evidence. Had he done the due diligence of checking, seeing, testing the waters with the area property owners, I don't think that petition would have been a surprise. I've been told that they've even almost doubled the number of signatures on that since last week. 98 land use plan he offered as new evidence. This seems like that if you're going to develop an area, you might want to know what the land use plan was for that area. That's not new evidence, at least not in my opinion. History of the zoning in the area. Again, you have an experienced developer. This is due diligence gives you all of this. This does not fall under, in my opinion, does not fall under or meet the level of new evidence. The other thing he listed as new evidence was the benefits of this industrial park. Is he going to stand here and tell this Board of Commissioners that when he first presented before you, he had no idea what the benefits of this were going to be? That's not new evidence. You know, he should have made that argument then. Okay, so I guess based on those 5 points of new evidence that he presented, I just honestly can't see what really is considered to be new evidence. Again, my opinion, but that's the decision that you as board
members. The new evidence being what he plans to do to protect the property and the the dust control that he's talking about, and the fence and the berm, that would be the new evidence.
My determination, my motion was, did we hear stuff here that was key to the information and helping us make a decision appropriate to this zone change? And I believe the information we heard tonight was new evidence appropriate for re-review,
It should
reconsideration.
be pointed out here when we are considering this, and it's your decision to consider that. This is rules for trial. This is not a trial. And to apply it exactly the same as the court would do, I don't think is the correct.
10.1P, which is on the third page, which is page 206 of the regulations down at the bottom. It's very short, very narrow in scope. It says no application for a zone change which has been denied wholly or in part by the board may be resubmitted for a period of 12 months from the date of said denial, except on the grounds of new evidence or proof of change of conditions. I think we can all agree that I don't think conditions have changed out there. So we have to do this on the grounds of new evidence. And what this is specifically referring to is that if there's new evidence, you would be able to waive the 12-month waiting period prior to resubmission. This is the specific regulation that this was brought before the board under, and it would be my contention that that's what you should be voting on tonight, is whether or not to allow this to be resubmitted prior to the 12-month waiting period as required under the regulations. That kind of pretty much summarizes what I'm at, but I just, since it was brought back to the board, or back before the board, specifically under this section of the regulations, I believe that's the section that you should be following with. I guess the only other thing I'd have, I find it kind of ironic, I don't know, maybe it's just me, but I find a little irony in the fact that Mr. Tyler's seeking zoning change from urban mixed residential to light industrial in order to build an industrial park that abuts up against the residential area on these 29 acres. While at the same time, over on Robertson Road, he's asking for exactly the opposite, a light industrial change, zoning change on 31 acres from light industrial to urban mixed residential so he can build or develop residences right up against the existing commercial area. So I just find the irony in that. So, but again, I really think that we should be considering just what we're voting on here tonight, or what you are voting on. That's all I have. Thank you.
Any questions? I've been over this territory over and over and over. So
You know what
please
you're
move on.
doing though? This is a public comment section. You should allow people to speak 3 minutes in a public comment section of your meeting. Don't you believe that?
Absolutely, and your 3 minutes are up. We've got other time. Well, but the issue about the new evidence is.
See, problems are already starting on this.
It's obvious we disagree, we agree to disagree, and we're just simply not going to go there. So if you have something else to offer, please do.
My next question is kind of a procedural question. With one commissioner absent tonight, and if this the possibility, let's say if it's 2-2, does that other, it goes down, right? Does that other commissioner, Mr. Keating, can he bring back the floor?
I think procedurally, I'd look at the Robert's Rules of Order, suggest only a commissioner that voted in the
So I was just wondering.
voted in favor can ask for in the winning side of the motion can ask for reconsideration. So if Mr. Keating is not participating in this, and we do end up voting tonight, Mr. Keating has no rights under our rules and regulations to bring it up and ask for reconsideration. Is that correct?
I believe that is correct, and I think were that the case, if we had a tie, we also have the additional problem of the Administrative Procedures Act, so it'd have to be renoticed and another hearing held sometime down the road.